Did you know there were some legal myths that could end you in jail? No? Well, keep watching and maybe you'll soon find out what they are with this video by LegalEagle called Legal Myths That Will Land You in Prison or slash Bad Legal Advice. I haven't really watched any videos by him, but let's get into it and see if we can stay out of jail with this one. Oh, captions were turned off for some reason.
So you've decided to do some crime.
Yeah.
Who hasn't? Well, thanks to those legal myths that TV shows and fake lawyers on Reddit continue to spread, you're probably in for the biggest surprise of your life.
What?
So the cops just burst through your door without a warrant, they didn't read you your Miranda rights, and you're probably going to be found guilty on nothing but circumstantial evidence, and you're defending yourself in the courtroom when it happens. Because even if you can't afford it, you are not entitled to an attorney. Because myth number one, if you can't afford an attorney, one will be appointed for you. Yes, that's right, you are not entitled to an attorney. Well, to be more accurate, it very much depends. The founders were really serious about giving people individual rights against police.
But American government said no, I'm guessing.
And prosecutors, and that's why the Sixth Amendment says, quote, in all criminal prosecutions, the accused shall enjoy the right to have the assistance of counsel for his defense. And the Supreme Court recognizes...
Is it like a, technically, it's not criminal thing? It's like legal, family court or something, maybe?
Why this is a foundational right. Quote, of all the rights that an accused person has, the right to be represented by counsel is by far the most pervasive, for it affects his ability to assert any other rights he may have. But the baseline right to an appointed attorney comes from the Supreme Court's 1963 decision in Gideon versus Wainwright, and in that case, a Florida man named Clarence Earl Gideon was charged with a felony and couldn't afford a lawyer. He asked the court to appoint one, but they said no because Florida only provided lawyers in capital cases. Capital cases are where the defendant, if convicted, could face death. Gideon defended himself, lost, and went to prison. He appealed all the way to the Supreme Court, which unanimously ruled that the Sixth Amendment guarantees the right to counsel in all criminal cases, even for those who can't afford to pay. But something got lost in translation because most people think this means you have a right to a free lawyer. Well, sort of. Gideon established a requirement that states must provide attorneys to indigent defendants in felony cases. In a later case, the court clarified that the right to counsel applies to misdemeanor and petty offenses as well, as long as the defendant faces the possibility of incarceration. Now, the Supreme Court probably should have just stopped it right there. Unfortunately, it wasn't done tinkering with the right to counsel. Instead of adopting a simple standard like you get a lawyer if the offense could lead to jail time, the Supreme Court pulled an Avril Lavigne and couldn't help but go and make things complicated. In Scott versus Illinois, the court held that the state does not have to provide a lawyer for a misdemeanor unless imprisonment is actually imposed by the judge. Oh, SCOTUS, why do you have to go and make things so complicated? I see the way you're ruling like some other country gets me frustrated. Now, in our video about America's most unhinged judges, I talked about how a Texas judge abused this very principle by coercing defendants into marriage in cases where jail was a possibility but not a certainty. Now, none of the people the judge pressured into marriage were represented by counsel, even though their charged offenses could have led to jail time. And that was a legal catch-22. You only get a lawyer if you're going to jail, but by the time you know that, you've already gone through your hearing without one. And as usual with constitutional rights, terms and conditions apply. The fine print says that even when you do qualify for a court-appointed lawyer, the process isn't automatic. You have to apply for it, disclose your financials, and wait for the court to assign someone. And about those financials, while the lawyer truly is free for those who qualify, not many people qualify. Who qualifies as too poor to afford an attorney varies from state to state and sometimes from county to county. Many states use a multiple of the federal poverty guidelines to determine indigency, and so in 2025, the federal poverty guideline for a single person was $15,650. And many states set their number at 125% of that guideline, which means that the person would have to earn less than $18,825 to get a free lawyer in those states. So yes, you have a right to counsel, but it's not a universal safety net. It's more like a conditional offer. If you're facing jail, if you're poor enough, and if the court says so, congrats, you get a lawyer. Else you better hope that the cops forget to read you your Miranda rights, because then you walk free. No arrest, no charges, just a smug smile as you strut out of the interrogation room, right? Myth number 2, police failed to read me my rights, case dismissed. Nope, that is wrong. But that hasn't stopped pop culture from spreading this myth. It's going to come as a shock, but real life is not a Medea movie.
You forgot to Mirandize her?
I never watched that.
I've got to let you go.
Now, the Miranda warning, which starts with you have the right to remain silent, comes from the 1966 Supreme Court case of Miranda versus Arizona. Before the police can interrogate someone who is in custody, they must inform them of their Fifth and Sixth Amendment rights, the right to remain silent and the right to an attorney. If they don't, any statements made during the interrogation can be thrown out under the exclusionary rule, which is the legal doctrine that bars illegally obtained evidence from trial. But Miranda only protects your words, not your actions. So if the cops find a kilo of meth in your trunk, no amount of unread rights is going to make that disappear. On top of that, according to the Supreme Court, Miranda only kicks in when there is a custodial interrogation. If a suspect voluntarily comes to the police station and talks, that doesn't mean he or she is in custody. The takeaway, Miranda applies when a reasonable person would feel they are not free to leave. If the police arrest you for that kilo of meth in your trunk, but don't ask any questions, no warning needed. If they ask you questions before you're arrested and you answer voluntarily, still no Miranda required. That's why failure to read Miranda rights isn't a get-out-of-jail-free card. So the next time a TV lawyer says they didn't read you your rights so the case gets thrown in the bin, know this: the only thing that's going in the bin is that script's grade for legal accuracy. Now, if your plan to avoid all this legal trouble is to just lay low at home where police can't get to you without a warrant, well, I've got some more bad news for you. Myth number 3, police can't enter your home without a warrant. Now, it's a staple of legal dramas and TikTok and Know Your Rights videos. Police need a warrant to enter your house.
This is my own should, at least. And I will not be harassed.
Now, to be fair to Jesse Pinkman, this myth is based on a real rule. The Fourth Amendment does protect your home from unreasonable searches and seizures. Generally, the police need a warrant to enter your residence. But there are so many exceptions to the warrant rule that they almost swallow the whole Fourth Amendment. If you've ever lived in LA and participated in our city's national pastime, watching car chases on live TV, you know just how common it is for suspects on the run to drive home like they're sliding into home base yelling safe.
Oh no, oh no.
But that's not how any of this works. Here's how it really works. A warrantless entry is usually considered unconstitutional unless it falls into a recognized exception like consent, hot pursuit, plain view, search incident to arrest, stop and frisk, special needs/administrative searches, and the automobile exception. But the biggest exception to the warrant requirement is exigent circumstances. Under that doctrine, police can enter a dwelling without a warrant
that falls under what I
an
said,
emergency,
right?
like someone is in danger, a suspect is about to flee, or evidence is about to be destroyed. Now that seems straightforward enough, but it's not. Imagine this: the police are chasing a suspect through an apartment complex. They lose track of him but smell marijuana coming from one of the units. They knock, loudly announce themselves as police, and then hear movement inside. The police officers think they hear people scrambling and a toilet flushing. Convinced evidence is being destroyed, the officers kick in the door and find drugs. But here's the twist: the suspect they were chasing wasn't even inside because the cops entered the wrong apartment. Now that happened in a real case called Kentucky versus King. The defendant in that apartment argued the police shouldn't have been allowed to enter without a warrant because the police themselves created the emergency by knocking and announcing their presence. But the Supreme Court sided with the police. As long as officers act lawfully by knocking and announcing, they're not barred from entering if they hear sounds suggesting evidence is being destroyed, even if the suspect isn't inside. And if the people inside react in a way that makes officers reasonably believe evidence is being destroyed, the cops can enter without a warrant. And there's an iconic scene at the end of Goodfellas where Karen Hill, panicked and desperate, races to the bathroom and flushes a stash of cocaine down the toilet just as the FBI closes in. And this is a textbook example of why the exigent circumstances exception exists. If the police had waited outside to get a warrant, the evidence would be long gone. And the law allows for that kind of split-second judgment. So while the Fourth Amendment does offer strong protections for your home, the phrase "you need a warrant" isn't a magic shield. If the police smell drugs, hear flushing toilets, or think someone's in danger, they might not need one. Now, if you believe any of these legal myths, you'll probably want a good lawyer. But if you want a great lawyer, let my law firm, the Eagle Team, help. If you've got in a car crash, suffered a data breach, especially if you got a data breach letter saying your information might have been leaked, or dealing with a workers' comp or social security issue, we can represent you or help find you the right attorney. And by the way, we don't get paid unless you do, so there's nothing up front. So just click on the link in the description or call the phone number on screen for a free consultation.
I never understand why people still do the letter.
So okay, you're busted. At least this is America, where our Constitution explicitly states that everyone is entitled to their day in court. Such a comforting thought. I think you know where this is going. Myth number 4, everyone is entitled to their day in court. Now in America, we do things by the book. And that means that if someone has wronged you or you were wrongfully accused, you get your chance to face off to prove your truth. It sounds like a constitutional promise. And yes, the Constitution does talk about trials. Article 3, Section 2 says, a trial of all crimes except in cases of impeachment shall be by jury. The Sixth Amendment guarantees that in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury. In 1968, the Supreme Court established that the right to a jury trial is a fundamental right applicable to the states through the 14th Amendment. That's all true. But here's why people believe that everyone is entitled to their day in court. The right to a trial is not absolute. In criminal court, the right to a jury trial only kicks in if the offense is considered serious. In Baldwin versus New York, the Supreme Court ruled that crimes punishable by more than 6 months in jail are serious enough to require a jury trial.
Right.
But for petty offenses with lighter penalties, you might face a judge, not a jury. And
But
even when
isn't that
trial is
still
possible, over 90% of
technically right to
criminal cases
trial?
end in plea deals, not courtroom battles.
Yes.
So you may be entitled to a trial in theory, but in practice, most people never have one. And in civil cases, you're not automatically guaranteed a full-blown trial at all. Most lawsuits never make it that far. They get dismissed, settled, or decided through motions like summary judgment, where the judge rules there's no need for a trial because the law clearly favors one side. And of course, we've all seen Harvey Specter settle a $1 billion lawsuit over bourbon and banter in the span of a single afternoon. But in real life, civil cases often drag on for years, and that's because in civil cases, there's no such thing as a right to a speedy trial, although that also depends state by state. But there are also legal
I had a
doctrines that make
family member get into an accident where the other person was clearly at fault, and they got basically permanently injured. So they did some kind of lawsuit against them. I forget the details, but it basically took years that they eventually just settled out of court. So, yeah.
hard for litigants to ever get their day in court. A major example is qualified immunity, a doctrine often invoked by police and government officials in civil rights cases. It shields them from liability unless the plaintiff can show that the official violated clearly established law. Defendants can appeal a denial of qualified immunity before trial, triggering years of appellate delay, while various courts try to determine whether a person has the right to sue the officers. So while you're technically suing, you might be stuck in legal limbo without ever setting foot in a courtroom. In Hollywood, justice is always served in 42 minutes plus commercials, but in the real world, your day in court may be hundreds of days waiting for the court to decide whether you're even allowed to ask for one. Which is why it's usually best to avoid trial in the first place, which you can do with this one neat trick. Just declare yourself a sovereign citizen. Myth number 5, the sovereign citizen loophole. Now, some Americans believe the government has no power over them because they're sovereign citizens, independent, self-governing individuals immune to the laws that apply to the rest of us.
Still
They've got a
don't
laundry list of legal
understand
theories
that.
to back this up, including the belief that they don't have to pay taxes and that the U.S. legal system has no jurisdiction over them. And you've probably seen some sweet, sweet justice shatter their delusions.
I'll step out of the vehicle for $500.
Step. You can search me for $500 cash.
I'll get in the car for $500.
But what you might not know about this stupid movement is that it's based on a legal theory inspired by a printer's error. The sovereign citizen idea originated with a group founded by Christian minister William Gale in the 1970s. His group, Posse Comitatus, believed that there was no higher authority than the county sheriff. It began as a group peddling your everyday stock racism and anti-Semitism, but when they started talking about the evils of taxation, the movement really took off. Which brings me to the printer's error that animates their legal theory. Sovereign citizens are 13thers, people who believe there is a secret 13th Amendment to the Constitution. Now, in the real world, the actual 13th Amendment, the one ratified by the states, abolished slavery. But 13thers think that an older amendment which failed to pass is actually the law of the land. The Titles of Nobility Amendment was a proposed amendment to the Constitution that would have stripped United States citizenship from any citizen who accepted a title of nobility from an emperor, king, prince, or foreign power. Congress passed it in 1812 during the panic about Napoleon's brother marrying an American citizen. You know, what happened if their son tried to become king of America? And freaking out about Napoleon's American nephew is like worrying about Prince Harry and Meghan Markle's daughter one day becoming queen of America. And Americans eventually figured that out, but a majority of the states never ratified the Nobility Amendment, and it's not part of the Constitution.
Okay.
Do you hear me, 13thers? It's not a real amendment.
I didn't know
However,
it
in
existed.
1815, a Philadelphia printing house made the mistake of including the unratified amendment in its volumes. The error was not fixed until 1845. So for 30 years, untold volumes of text went out in the world
30?
representing that the 13th Amendment had passed ratification. But when the real 13th Amendment passed ratification and abolished slavery, the consequences were seismic enough to clear up any confusion about the typo. But that didn't stop conspiracy theorist David Dodge in the early 1980s
How do you
from finding
not
himself a
notice
copy of the
for
Constitution
30
with this error
years?
and having a big eureka but stupid moment. He concocted an elaborate conspiracy that this secret 13th Amendment actually invalidates the entire U.S. justice system. Why? Because lawyers and judges have titles. Lawyers use the title Esquire, and judges are known as the Honorable or, Your Honor. So sovereign citizens think that lawyers and judges, through licensure, accept titles and therefore are no longer American citizens. Now, all of this, of course, has been thoroughly rejected by the courts. So sadly, I can't force anyone to call me Sir Devon Stone, defender of the sovereign laws, or LegalEagle, Baron of the Bench, and titles of nobility are already banned banned by the Constitution. See Article 1, Section 9, Clause 8. So America doesn't have an official aristocracy. When
No
a
one
lawyer
can
dies,
call
their
me
children
King
don't inherit
Mistic.
the law license. And lawyers are still U.S. citizens, at least for now. But it doesn't matter how many times the courts slap this theory down, people just won't give up on it. And sovereign citizen lore is beloved by jailhouse lawyers, inmates who know just enough law to file long-winded legal briefs arguing that the courts do not have any jurisdiction over their cases. And you can probably excuse people with no legal training who barely have access to a law library from falling into the sovereign citizen trap. But this bogus legal theory has also been championed by people who should know better, like the Iowa Republican Party. Iowa Republicans put the missing 13th Amendment into their 2010 party platform, and they tried to argue that President Obama forfeited his citizenship by accepting an award from the Nobel Prize Committee, which was apparently a foreign state. And although this is funny in the abstract, conspiracy theories can have some serious consequences. Over the years, the movement has fanned out from its anti-Semitic and racist origins. The sovereign citizen movement now attracts people of every race, religion, and political persuasion. Unfortunately, I mean, we're all for diversity and equality, but maybe not about something that's incredibly stupid. But sovereign citizens have been known to file notices of liens against property for the purpose of harassing the true owner. And this tactic, which has been called paper terrorism, clouds title to real estate and other property. People espousing sovereign citizen theory produce fake arrest warrants, forge banknotes, and even issue their own currency, which, I shouldn't have to tell you this, are very much crimes. But let's say that doesn't stop you from picking up some criminal charges. You finally get your day in court, and you're feeling optimistic that the jury's going to find you not guilty for all the wacky sovereign citizen crime you definitely did not do, you rascal, because all the state's evidence is circumstantial. Myth number 6, all the evidence is circumstantial, they'll never convict me. You've heard it in courtroom dramas, shouted by defendants who think they've found a loophole. You can't convict me, all the evidence is just merely circumstantial. Even Law and Order is guilty of this one.
There's circumstantial evidence and a statement from his son.
Now, this won't do at all.
And the idea is that if there's no smoking gun, no eyewitnesses, and no confession, then the prosecution doesn't have a case. But here's the truth. Circumstantial evidence is not only admissible, it's often just as strong and sometimes stronger than what we call direct evidence. But let's define some terms here. Direct evidence is evidence that directly proves a key fact at issue without needing any inferences. So an example is an eyewitness saw the crime, a video...
And even if there's still direct evidence, you still have a chance of walking free. Especially if your name is Casey Anthony.
Or the weapon used in the crime, and circumstantial evidence is evidence that requires an inference to connect it to a conclusion. Examples include forensic evidence such as fingerprints and bloodstains, or documentary evidence like business records or text messages. If a witness testifies that they saw you stab someone, that's direct evidence. But if they say they saw you leave the victim's house at midnight covered in blood, and then watched you toss a knife into a storm drain, well, that's circumstantial.
Really?
But that seems pretty strong.
And
a jury can convict you on that evidence alone. And that's why juries are routinely instructed that the law makes no distinction between the weight or value to be given to either direct or circumstantial evidence. Circumstantial evidence is not a lesser form of proof, it's just a different kind. As the Supreme Court has long recognized, circumstantial evidence is not only sufficient, but also maybe more certain, satisfying, and persuasive than direct evidence. And in fact, most juries believe that DNA evidence is the gold standard for determining whether someone is guilty. But DNA evidence is generally considered circumstantial. It does not directly prove a crime was committed, but it can be used to infer a connection between a person and the crime scene or an object. So circumstantial evidence isn't lesser evidence. Pop culture gets that wrong a lot. But lawyers can definitely attack the inferences drawn from the circumstantial evidence. And when it comes to destroying circumstantial evidence, no movie has ever been more accurate than My Cousin Vinny.
What is this rusty, dusty, dirty-looking thing over your window?
It's a screen.
A screen. It's a screen.
He is walking the witness down a logical path that he's not going to be able to get out of, which is that there's a lot of stuff between his vantage point and the events that he is an eyewitness to. And the eponymous Vinny doesn't argue that the evidence is invalid because it's circumstantial. He just shows that it leads to the wrong conclusion. Now, My Cousin Vinny's mastery of circumstantial evidence is a big reason why I called it the perfect legal movie, and that's because of its screenwriter, Dale Launer. And if you love the movie like I do, you can check out the extended cut of my interview with the screenwriter on today's sponsor, Nebula, where we really get into the legal nuances of this masterpiece of courtroom drama. And for limited time, you can get a lifetime membership for Nebula. You can buy once and then never again. It's the greatest steal of all.
Okay, I don't think there's any other tips added, so check that out and check out his video down below if you would like. And are there any other legal myths that I might need to know if I do anything in the future? Which I won't, but if I should know. Also, I don't know if this is still like something people believe, but another myth is that polygraphs actually work. They do not. They aren't even usable in court. They suck ass. They can be tricked so easily. Do not take a polygraph. Do not. Just ask for a lawyer. Don't ever talk to the cops as a suspect. Or ever. But not the point. But until next time, bye.